one that's near and dear to my heart and still a source of pain that the court denied the Utah case back in October. But it's not that unusual for the court just to decide not to take up a difficult issue because they're not ready to. And obviously there were people within the court and more than a majority of the court that felt like the time just wasn't right. And the advantage of waiting for the Sixth Circuit opinion is that then there really was a clear circuit split on the question post Windsor after the Doman decision from 2 years ago, and so then I think pretty much all the justices felt like we really have to take this up now when the circuits are going different ways in their interpretation of our decision in Windsor. Prior to that, they weren't conflicting in their interpretation of the Windsor decision. As to your second question about what will happen in these other states, it'll really be up to the governors and the attorneys general of those other states to decide how to proceed. Once assuming the Supreme Court rules and affirms the Sixth Circuit decision and thereby upholds the marriage laws of Michigan and the other states, as a matter of law, the court will have established that yes, states do indeed have the right to maintain the traditional definition of marriage if they want to. So the question is, how do they go about getting out from under the rulings that have been issued before? And there are various ways that they could do that. One way would be for the governor just to direct people in the state. Look, we've had a decision from the Supreme Court that establishes that our law is valid, and so from this point forward, we're going to go back to respecting the law that the people or their representatives adopted, and then wait for the other side to sue them if they want. Another option would be for the Attorney General in a state to go back into the district court that ruled against the traditional marriage law and ask that district court to make a motion for relief from judgment and ask the district court just to vacate his or her prior opinion in light of the Supreme Court's more recent ruling. And then if the district court denies that motion, which they shouldn't, I mean that's a motion that any district court should grant, but if for some reason they deny that motion, then that denial can then be appealed up through the system, and then ultimately the Supreme Court, if it has to, can fix it.
One other observation to throw into the mix on the stays is what we saw yesterday is, and at least what I saw, is that Kennedy's still struggling with this issue. And if everyone else on the court thought that Kennedy was struggling with this issue, everyone might have decided, we don't want to grant cert. The four more conservative justices might have thought, well, we don't know how he's going to rule on this, so we don't really want to bring it up unless we have to. The four more liberal justices might have had similar thoughts. So at the end of the day, they might have really been thinking, until we have to decide this, we're not sure how this is going to go, so we're not going to rush into this. And then once the Sixth Circuit created the circuit split, at that point they had to take it. So that's another way to read it.
Other questions? Yep, right in the middle. Can we do this way?
We're always so encouraged when we hear people like you make your explanations for, why judges might rule the way they should. In the end, they might, some of them will go by rule of law, and this is the way it should be. Others will rule, oh, I don't think that's a good thing anymore. We should change it. That's what we maybe think in this crowd. But what can you do when a judge doesn't rule by the law, and it seems obvious to everyone that they're going by their current personal opinion?
This, unfortunately, is what part of the harm to our judicial system when given some of the theories of constitutional interpretation, for example, where this sort of evolving constitution that we've seen and things like that, where it allows judges, in some cases, gives them a fig leaf for coming up with what their own policy preferences would be and substituting that for the law. I think ultimately our best response, at least in the federal system, where we unfortunately, is to pay very close attention to how those judges get there. I'm someone who follows judicial nominations very closely, and I think realizing that when you're electing a president, when you're electing your senators, you are electing the people who are going to be putting these people on the court. And it's not a quick fix, because again, these are all individuals with life tenure, but we need to be very aware that that's actually one of the most important things, in my opinion, that a president does, is nominate judges, because the laws they sign may be overturned by a future court, may be revoked tomorrow. The executive orders they do could be undone in 4 years very easily, but the judges they put on the court are there for the rest of that judge's life term. And unfortunately, we have a system in which judges often, I think, do substitute their own positions for the Constitution itself. If we knew that everyone of whatever political preference they are is going to still follow a very strict method of constitutional interpretation, then it wouldn't even matter, I think, hopefully, whether a Democrat or Republican appointed them. You should end up with people who are going to come to very similar results in most cases. Obviously, there are very close cases that judges with similar interpretation can differ on, but I think we wouldn't be in the same situation we are now, where even every judicial nomination turns into a big political circus, because we have all these litmus tests and stuff. It's because people are afraid that judges are going to substitute their views for those that are established in law and those that are enshrined in the Constitution. So I think we all need to